Hi, I'm Pinky Ananda, a U.S. immigration lawyer. If you or someone you know has a marriage-based green card, you might be wondering, can someone with this type of green card actually be deported? The short answer is yes, it's possible, but it depends on the circumstances. Today, I'll break this down for you. We'll talk about the grounds for deportation on a marriage-based green card, how to avoid those risks, and even clear up some misconceptions. Let's get started. First, let's talk about one of the most serious grounds for deportation, a fraudulent marriage. This happens when someone enters into a marriage solely to obtain immigration benefits. If the government finds evidence that the marriage wasn't genuine, they can revoke the green card and start removal proceedings. This can happen even years after the green card is issued if new evidence comes to light. Now, what's important here is to document your relationship thoroughly. Things like joint bank accounts, shared leases, and even photos of family holidays help demonstrate a bona fide marriage. Now, another common issue is failing to remove the conditions on a green card. If you have a conditional green card, which is typically issued when the marriage is less than 2 years old, you need to file Form I-751 to remove those conditions. This must be done during the 90-day window before the green card expires. Now, if you miss this deadline or don't provide enough evidence to prove the marriage is legitimate, you could lose your status and face deportation. Next are criminal offenses. Certain crimes like aggravated felonies, drug offenses, or crimes of moral turpitude can make someone deportable even if they have a green card. For example, a single DUI might not lead to deportation, but if it's combined with other factors like endangering a child, it could. Immigration law treats criminal convictions very seriously. So if you're ever charged with a crime, it's crucial to consult both a criminal defense attorney and an immigration lawyer. Lastly, immigration violations. This can include things like overstaying a visa before adjusting status, working without authorization, or lying on immigration forms. So how can you avoid these risks? Be honest and thorough in your applications. Never misrepresent facts or provide false information. And maintain good records. Keep documentation of your marriage and finances. File all necessary forms on time because missing deadlines like the I-751 removal of conditions can be costly. Also, stay informed. If you are unsure about any part of the process or receive any communication from USCIS, consult a lawyer immediately. Proactively addressing these steps can help minimize risks and keep your status secure. Now let's talk about misconception about marriage-based green cards and deportation. Let's clear up some misconceptions. Many people think that once they get a marriage-based green card, they're immune to deportation. That's not true. While a green card grants lawful permanent residence, it doesn't provide absolute protection. Another misconception is that USCIS doesn't revisit approved green card cases. In reality, they can. For example, if you apply for naturalization down the line, USCIS will review your entire immigration history. Finally, some believe that minor mistakes on forms won't matter. But in immigration law, even small errors or omissions can lead to big consequences. Always double-check your applications and seek legal advice when needed. So as a recap, can someone with a marriage green card get deported? Yes, it's possible under certain circumstances like fraud, failure to meet requirements, criminal activity, or immigration violations. But the good news is these risks can often be avoided with proper preparation and legal guidance. If you have concerns about your marriage green card status or need help with your case, please schedule a consultation so we can discuss your situation. Follow for more updates on immigration topics, and we'll see you in our next video.